All right. Welcome, welcome, welcome. Happy New Year. It is January 27th. It is our monthly installment of Work Comp Today. Welcome, Dave. How's your day going, bud?
Hey, it's going great. Thank you. Hope you're doing well also.
You know, your enthusiasm is so overwhelming and contagious. Annemarie Pantazis is our guest. She's out of North Carolina, and she's been a friend of ours for a while. We know her through the national organization, WILD, and Dave will talk about that in a little while. Welcome, Annemarie. How are you doing today?
Great. Thanks, guys. Thanks for having me. This is so exciting. Comp nerd stuff. I love it.
Oh, yeah. We do this each month. We didn't do it last month. We got a little busy toward the end of the year, but we are back with a monthly installments going forward. We got a bunch of guests lined up for the next several months. But what we do, for those of you who haven't seen our show, what we do each month is we talk about the current topics of the preceding month that impact our practices, most notably work comp, independent contractors, employees, employers, and anything dealing with employment settings and particularly injuries. And we've got about 5 cases from around the country we're going to critique and kind of break down a little bit. We're going to share how North Carolina deals with them. We're going to talk about how Alabama deals with them and how people who may be watching this maybe can learn a little bit, regardless of what state you're from. But before we do that, Annemarie, I want you to share a little bit about your firm and your practice. And before we get going, let's hear a little bit about that.
Well, thank you. I appreciate that. And thanks for having me on. This is fun for me. So my name's Annemarie Pantazis. I practice in Charlotte, North Carolina. I've been practicing workers' comp for 22 years. I would say 19 of which have been on the plaintiff side. So I do all comp all the time. I'm a board certified specialist. I actually sit on or chair the committee that certifies other specialists in our state. So we write and grade the specialization exam. And, just do a lot of speaking, talking nationally and locally about issues related to workers' comp. And what I find fascinating about workers' comp, it's just pervasive. It's everywhere. You wouldn't even think when you read the news that a lot of what you see does have a workers' comp component to it. So I've really enjoyed it. I really enjoy representing injured folks, but I've also been on the other side at the beginning of my career representing carriers. So I think I have a little bit of a perspective from that side too. But that's what we do.
Absolutely. That's the reason why we've got you here, that we do the same kind of work. Our practices, while we're in different states, there are so many common themes, regardless of what state that you're in. And no matter what happens in your state by way of law, there's things that we can learn from each other. And that's why we're here together today. So guys, let's just dive into our first case. All of these are to me, they're so interesting, but maybe that's because we do this kind of work. And as David has quite often labeled this monthly show, it's Work Comp for Nerds or Work Comp Nerds, just going through this. But this first case is The Bus Is Coming, But Mind the Gap out of Illinois. Dave, did you get a chance to look at this coming and going case?
Yeah, I did. And so the cases we're going to discuss today, they were actually compiled by Thomas Robinson, who has a blog called The Work Comp Writer. And I get emails every week from him with case summaries from around the country. And he compiled this top 10 bizarre workers' comp cases for 2021. So we're going to take 4 or 5 of these cases and review them. So our first case, it comes out of Illinois. And interestingly, the injured worker, the injured employee in this case is a lawyer. And he's an older gentleman. And he received a call from his office and said, hey, we've got this really important client coming in. He actually showed up a couple hours early for his appointment. So we need you to get here as quick as you can. So he gets dressed real fast and hurries down to his local bus stop. And that's where his accident takes place. He stepped off the curb and he tripped and fell. And then he had a serious injury to his shoulder. So that's kind of the background of it. Anything I left off about how he got hurt and why he got hurt?
I think those are the key parts of this that I read. And he ended up having a torn rotator cuff was his injury.
Yeah. So his claim was denied. So he files a lawsuit for work comp benefits, and as it turns out, the court said that he was not entitled to work comp benefits, or as we call in Alabama, it wasn't a compensable claim, because the defense was the going and coming rule, or coming and going rule, which means if you're on your way to work or you're on your way home from work, that's generally not going to be covered by your employer's work comp carrier.
Annemarie, if this case is in your state, talk just a little bit about the coming and going rule, and how do you think that it would be ruled on in this case?
It's funny, my very first CLE presentation was on the going and coming rule when I was a baby lawyer way back in 2000. So I was pretty familiar with this particular fact pattern. So in North Carolina, sounds similar to Alabama. We have the going and coming rule, which, as you stated, injuries on your commute either to or from work are generally not compensable unless there's some other element that takes it out of just an ordinary commute. And the reason is, if you get hurt on your commute, you're exposed to the hazards that the general public is equally exposed, meaning, you're not placed at an increased risk because of your job on your commute. So the only I think, to answer your question, this would be denied in North Carolina too. I think the only thing as a plaintiff's attorney we could argue is maybe the rushing or the hurrying maybe have placed him at a greater risk for tripping and falling. But if you do an analogy with a car, if you're speeding to get to work and you're in a car accident, it's not going to be compensable just because you were going faster than the speed limit. So I would say, if you're rushing and you miss a step or a crack on the sidewalk, then it's the same thing as speeding in a car. It's just not going to be incident to your employment. It would be interesting if, the employer paid for his bus ticket, or if there was some special reason he had to take this bus incident to his employment. But other than that, I would say it would also be denied in North Carolina too.
Like every work comp case we've ever analyzed, they're all so fact specific.
That's right.
Just referenced, had you thrown in just one more key piece of information, it might have made it a compensable claim.
That's right. And I think that's what we have to do on these cases, is just really dive deep into our client's history and just say, okay, let's ask these picky little questions and try to find one element that may take it out of the general rule. But in this case, I just don't see that extra element.
And I think you both would agree with me. That's what makes it so dangerous. When you get a brand new potential client who calls and says, I just need 2 minutes of your time. I just need a minute of your time. And as I say to them, I'll be glad to talk to you, but it's just like if you went to a doctor's office or your accountant or any other professional that you need some input from. Do you really expect a 1 minute response to set you on your path of what you're looking for? That's so dangerous. But we want to be helpful, but we need more time than just the 1 or 2 minutes.
And I think you make a good point too. A lot of times clients have already given a recorded statement to the adjuster by the time they come see us, and they may not know to throw in some of these extra elements, or the adjuster might be asking questions in a way to get them to agree that it wouldn't be compensable for a lot of reasons. So yeah, talking to an adjuster without an attorney is always a do it at your own risk.
Yeah. Dave, anything else from this case to add, or that an Alabama slant on it?
No, like I said, I think if this case happens in Alabama, it's probably not going to be compensable either. Yeah. It's a denied claim.
I think you both may have mentioned it, but the fact that he mentioned that he was an on-call employee, I thought was an interesting fact that he was trying to assert, but it didn't quite get where he needed it to go fully. All right, guys, let's shift to the second one. This one is out of, this is my favorite one of the group, this poor fella out of New York. And it's titled Restaurant Worker Beaten by Angry Karaoke Customers. Holy smokes. Annemarie, are you a fan of karaoke?
I am a fan of listening to other people do karaoke, but I am not a fan of trying to do it myself.
Have you ever witnessed an angry mob come back into a place and beat up a dude?
In my experience, people are happy. They are substantively happy when they're doing karaoke. I don't see anyone doing karaoke when they're not under the influence of some happy substance. So yeah, an angry karaoke mob would be kind of funny to imagine.
Well,
what could be so bad during karaoke, right?
I asked you this first because we all know where Dave hangs out, and he's got some expertise on this one, but I'm going to let you field the first part of it, Annemarie, about was this compensable ultimately, and why or why not? What did the court or the decision maker, they hang their hats on here?
So the way I read this is that the injured person was trying to get it outside of the workers' compensation system and into the civil tort system so they can get pain and suffering. You know, one of the things our clients always ask us is, I had a lot of pain and I suffered, and this injury was the fault of my employer, and I should get paid for all of this. And you really can only do that if you can figure out a way to get the claim outside of the workers' compensation system, because it's such a limited remedy. So conversely, the employers want to keep it within the system, so they have, a finite universe of damages that they have to pay. So the way I read this is that there was some sort of parent company to the bar where this person worked, and the person was trying to sue the parent company for negligent security or training or something to that effect. And the court said, no, in this situation, what's called the exclusivity principle, where you can't sue your employer outside of workers' compensation unless there are very specific reasons. The exclusivity protection extended to the parent company in this situation. And I think that would have been the same outcome in North Carolina too, quite frankly.
Dave, any Alabama slant to this? Do we have any karaoke cases reported on the books that you're aware of?
I'll change the fact pattern just a little bit and assume, that these customers, say this happens in Alabama, and it was customers that assaulted him, beat him, or shot him, or even if it was a coworker that shot him or beat him, then that's going to be covered under work comp in Alabama, so long as there's a connection between the employment and the assault. So, and we've handled plenty of cases like that where coworkers get in fights, coworkers shoot coworkers, customers shoot people working at fast food or businesses. And so that is going to be covered so long as the dispute arises or is related to the employment.
Yeah. It can be a situation where they come back and commit the assault. It doesn't have to be at the same time. And you're so right. We've handled so many of those. And again, it just goes back to the fact specific pattern ultimately determines whether there's going to be some compensability or not. All right, guys, we can move on to number 3. This one's in Missouri. And it's been entitled, I'm sorry. This one is, in Missouri. Take smaller bites. Worker chokes on breakfast sandwich, has serious vehicle accident. I'm going to assume we all at some point or another eat or drink in our car commuting from X to Y locations. It's just the rare person who doesn't do something like that. Dave, looking at this one, this fella had a single vehicle crash when he choked on a breakfast sandwich he had just purchased, blacked out, and crashed on the side of the road. And he sought work comp benefits. How did the court or the decision maker in this one ultimately decide?
Well, the first judge actually, I think, said it wasn't this one? The first judge said he was, no.
Yeah.
Yeah, that's right. The first judge said it was compensable. That's right. The first judge ruled for the injured worker that it occurred while he was working, but then it was appealed by the employer or work comp and said, no, this wasn't a work-related injury. And it actually turned out to be denied because there wasn't a causal connection between the employment and his injuries. Yeah. They said that the employer did not require him to eat his breakfast after starting the work day. And his testimony, in fact, he said that he could have eaten breakfast before he actually went on the clock and started his job. So his work while he was in a work vehicle, and I think he was on his way to a job site. His injuries did not arise out of in the course of his employment.
Annemarie, one of the things that I suspect you deal with, just like we have in our practices, is you got into this line of work because you want to help others. Mm-hmm. You want to help those who need it the most. And Dave accuses me more that he's better at it than I am. If there's somebody who's really, really been injured, I want to find a way the law can help them.
Absolutely.
And unfortunately, admittedly, had this case come in our office, I would have been hard pressed not to take the case.
I would have not only taken the case, I think this is a winner in North Carolina, truthfully. I think
share the North Carolina slant on this.
Yeah, I think there's a couple things. We have a direct case, appellate case on point that says when you're in a car accident at work, even if there's, and I think in this case, somebody blacked out, had a medical situation and crashed their car, single car accident. And even though the blacking out wasn't related to work, the fact that they were in a car placed them at an increased risk for injury should something happen to them while they were in the car. So in North Carolina, I think that increased risk of being in the car, sustaining the choking hazard, and then ultimately getting injured would put it into the arising out of employment, because that's what we look at. Does the employment have an increased risk to the causing the injury? But if you take it one step further, he was in a company car. We also have something, and so that would be an exception to the going and coming rule if you're in a company provided transportation. So it does say that he was going to his first morning appointment, so presumably he was already in the course of his employment. But more so than that, in North Carolina, we have something called the personal comfort doctrine, which means that if you're eating lunch or you're doing something for your own personal comfort, your personal comfort makes you a better employee that benefits your employer because you're going to be more productive, you're not hungry, you're satisfied, et cetera, et cetera. So had this happened on a lunch break in the lunchroom, I think it would have been compensable too under the personal comfort doctrine. So I think there would be a lot of ways in North Carolina to win this case, truthfully.
Let me pose to you both. Let's change the facts just a little bit. He's in a company car coming from home on his way to his regular route. Mm-hmm. On his way to the office. But he stops at a McDonald's or someplace and picks up his breakfast. And then this occurs, or that he has an accident, but he's still in his normal pattern, his normal route that the employer knows about. It's an 8 to 10 minute drive. Does that change anything in Alabama, Dave? Does that make it compensable for him?
If he's driving from home, going to the office in the morning, no, I don't think that makes it compensable. I would say, I'll add this. If his boss said, hey, stop at McDonald's on your way in and pick up a dozen biscuits for the office, let's have some, do that, then it might be covered under work comp.
Well, now he's furthering the business. He's furthering the interest of the company as opposed to his personal. Annemarie, let's change it even a little bit more. He stopped at McDonald's, he got his food. He's not coming into the office, but he's going to his client's office, a preset time, whatever, that his employer expects him to make that appointment because it's a client of the firm or his business. And then this occurs. Does that change anything?
So in North Carolina, the fact that he's in an employer-provided car is a point in his favor. There's some technical rules about it has to be incident to a contract of employment, and who pays for the gas and the mileage and all that. So I think there's a point in his favor for being in an employer-sponsored car. Going to your first morning appointment, if you don't have to go to the office first and you're going to your first appointment, we've had cases in North Carolina like nurses that, home health care are going from their house to their appointment. Those cases have been found to be compensable because you're starting your work routine. You're not going to the office, you're going somewhere different. You're more like a traveling salesperson or business trip, exception to the going and coming rule when you're going someplace different than your actual office. Now, if you don't have an office, that gets a little bit dicier. If every day you're going to a different place, that again turns on those specific facts. In those cases, I hate to say it, usually settle. You know, if you've got 2 factors in your favor, 2 factors in the other side's favor, you know, we try to work those out.
And, you know, particularly if they're really bad injuries, that kind of forces the issue toward mediation a lot of times. And I want to welcome everybody who's watching us live or may catch us later on. We are doing our monthly work comp today on YouTube, our live show. Dave and I have been doing this for a couple of years now. We do it every month with a friend, a colleague who from some part of the country does the same kind or similar work from a practice standpoint that we do. Our guest this month is Annemarie Pantazis out of North Carolina. And we're just zipping through some really interesting cases. Interesting if you're a work nerd like we are, that we hope folks who are watching this can learn a little bit and maybe relate to, hopefully not too bad for them, but maybe they have cases like this or have questions. Annemarie's out of North Carolina. Dave and I are in Alabama, and we'd be glad to speak with you guys. And we're going to put Annemarie's contact information in the show notes when we get finished. And we've gone through cases out of Illinois, New York, Missouri, and now we're headed out west, far west to Oregon, dealing with energy drinks. Annemarie, what in the world is going on in this case, and how could an exploding energy drink A, cause injury, or B, be compensable under comp?
You know, we had the exploding e-cigarette. You know, in North Carolina, you have to change the fact pattern to the exploding e-cigarette. And it was actually up in Winston-Salem, tobacco country. So, but we did. In North Carolina, we had a guy who went to the convenience store, got an e-cigarette, didn't, I guess, light it correctly, and it exploded, and he fell out of his truck and onto the pavement and filed a comp claim for that. So it's a little bit similar to the energy drink being consumed during the mandatory break period, and the top popped and caught the guy in the eye. And in this case, I think the board declined to give benefits. Am I reading that right? It says that the risk was not personal to the employee. The employer did not supply the drinks for the workers.
The Oregon Work Comp Board disagreed with the employer and awarded benefits.
Oh, I'm sorry. I think that's what would have happened in North Carolina too. Yeah. And I think the determinative factor in this case is that it was during a mandatory paid lunch break or break.
Yeah, and the employer didn't supply anything for their people. They had to bring in their own.
That's right. That's right. I think North Carolina would have ruled in the same direction, but you change the fact pattern. You're at a convenience store on your break, and you're getting an e-cigarette, and you fall out of your truck. That's not going to be compensable. So again, it's very fact specific as far as, you know, mandatory lunch break. The employer didn't provide drinks. But it was a fun one to watch in North Carolina. It was argued pretty well too on both sides.
The title of it was, "How much power is stored in one of those little energy drinks?" That's so funny. Dave, I'm going to change the facts on you a little bit. 2 lawyers who you know go to the YMCA on their lunch break and have an eating competition. And the one guy who does the competition gets sick afterwards and applies for benefits. Does that make it a compensable case?
Probably not, because the employer wasn't requiring the employees to work out at lunch and have an eating contest.
Okay, just asking. It didn't happen. Just made it up. Just asking though.
That reminds me of the gluten-free pizza injury that was on this list, where the lawyer ate the gluten-free pizza and freaked out.
Yeah, I couldn't add that to this list. It just was not. I want people to take it seriously around here.
Yeah.
All right, guys, we're going to move on to our 5th and final case, and it seems like we have a lot of cases every month. New York just seems to produce its fair share of cases, and the title of this one is, and this one's terrible, "You mean I have to put my foot down there?" And this is dealing with a grave digger who was required to step onto the top of caskets during the burial process. And what is a little different, unique to this one is there's mental injury claims. Dave, how do you see this one from the New York standpoint? You can tell us how they ruled. And then what would the great state of Alabama do with this one?
So I don't think that, well, let's just talk about Alabama real quick, okay? Because New York does it a little bit differently than we do. This case is going to fail in Alabama if you bring it just for workers' compensation benefits, because there was no physical injury first. All right. So in order for there to be a mental injury or psychological claim brought under Alabama work comp, there first has to be a physical injury. So here, this employee, the gravedigger, he's not alleging a physical injury. He's alleging only a mental or emotional injury. So that claim is going to fail under the Alabama Workers' Compensation Act.
And I know we've looked at the nationwide. Of course, Alabama, like many parts of our compact, fails to protect injured workers from that standpoint. But many states have started enacting over the last few years just mental claims. What about North Carolina? How would North Carolina treat this particular case?
This particular case, I don't think would be compensable, but to add on to the mental claim issue, so we have two types of mental claims: the physical mental claims, meaning mental claims precipitated by a physical injury, and that's what we see most likely. You know, you get hurt or something happens at work and you get PTSD, stress, anxiety, depression, all of that. That is compensable if the doctor links it up to the physical injury. But we do have a subset of what we call mental claims, and our courts do realize or recognize mental claims in very limited circumstances, and it's got to be bad. A lot of times it's when a first responder sees something really catastrophic happen, a child die, somebody's, head gets shot off, or, something really, really bad, for a mental image to produce a mental illness. There was the seminal case that was interesting in North Carolina. It was a guy who was working on a drawbridge. He's the drawbridge tender, and it was down east. We call that down east North Carolina, where near the coast where the military bases are, and the military had scheduled exercises. And one of the exercises was to go take the bridge, but somebody forgot to tell the bridge tender that they were coming to take the bridge. And so he literally thought there was an attack coming on his bridge with all of these Army vehicles coming up into, and it was at night. It really freaked him out. And the court said, okay, we'll give you that one. We'll acknowledge your mental stress from the attack on the bridge. But it's got to be a very unusual circumstance. And I don't think this fact pattern would support a mental claim in North Carolina. And I think in New York, he was trying to get it outside of the Workers' Comp Act and say it was an intentional tort. And again, I don't think that would go very far.
I think unfortunately for this one, that was not pled properly.
Right.
Because it says no allegations of intentional acts were contained in the plaintiff's complaint. That's too bad, because that means they did not, at least for this round of the case, get to actually litigate that part that really is important.
I will say we get a lot of calls. I call them the bad boss cases. I got a really bad boss, or I'm a school teacher and these kids are really stressing me out. My boss called me into the office and dressed me down and I didn't deserve it. Now I've got depression, anxiety, and can't go back to work. Those bad boss cases are not compensable in North Carolina. So we do get our fair share of calls about that. And I say, well, maybe you could call an employment law lawyer. Maybe there's something in that area.
Dave, we look at so many of those from an actual employment standpoint. What do you tell our callers in Alabama?
One of my common lines to people, Annemarie, when they call with that very similar situation is people get to be jerks. Mm-hmm. And it doesn't give you're not going to be successful in a court case just because someone's a jerk.
Right.
It's just not enough there's just not enough there to pursue a case.
Yeah. It's the at-will employment statutes and the way that they're treated in Alabama do not give the typical employee much legal protections across the board. Well, guys, that's all of our cases for this month. Those 5 cases are always of interest and just unique. And as we said, all cases that we get to look at or people who call us with the potential matters, we've got to take them step by step, fact by fact, and figure out, is there some way in there that benefits should be afforded? And Anne-Marie, I know you do that as well. And sometimes it takes more time than others. It may be a 10-minute conversation, or it may be a full-on 45 minutes to an hour, depending on how complicated the matter is. So thank you for running through those with us. But before we get out of here, the other part that we usually do, because our guests are typically from out of state, we like to do a little bit of a comparison. And this is really where it gets depressing for David and me. We do a comparison of our guests' home state statutes and laws and procedures with work comp with good old Alabama's procedures and laws. So I'm going to take the first one. Dave, I'm going to let you jump off here. Okay. We often will resolve our cases through a settlement. I mean, almost exclusively, we rarely try them these days. But as part of the settlement terms, what we call it, if medicals are left open for life, what does that mean? It doesn't always mean for life, but how does that go?
Okay, so what that means is if the medicals settle or the claim settles with medical benefits open, really nothing will change for the injured worker. In other words, work comp will continue to pay for the authorized medical care. So the injured worker will continue to see the authorized doctor, and work comp will pay for the medical bills, the doctor, the pharmacy, physical therapy, whatever the doctor orders. But it just means that they got to continue to treat with the authorized doctor. They can't go find their own doctor and then ask work comp to pay for it.
Anne-Marie, let's take the same scenario when you resolve a matter, whether it's through an ALJ, administrative law judge hearing, or you settle it in some fashion. And as part of the terms of the resolution, you have open medicals. Is that an option? First of all, is that an option for you in North Carolina? And if it is, what does that mean?
Well, it's always an option, but it's rarely an option that the carriers and adjusters agree to. We usually, what we call clincher our cases in North Carolina. I would say 90% of all workers' comp cases that resolve on a full and final basis, meaning we look into our crystal ball, we determine how much medical is remaining, we quantify that as best we can. We look at the indemnity. So half the claim is medical, the other half is indemnity, the weekly checks, the rating, that sort of thing. And so we combine both of those elements into one settlement in a lump sum that then relieves the carrier of any future obligation. And usually our clients like that better because they like to control their own outcomes. A lot of our folks don't trust the workers' comp doctors, not that they're not trustworthy, it's just because they don't have the right to pick their doctor in North Carolina. We're an employer-directed state. I think that trust factor isn't really built up at the beginning of the situation. So to answer your question, open medicals usually only remain open when we go win a case. Just say there's a denied case that we win at the, we call them deputy commissioners or ALJs. Our cases are tried before a judge, but they're workers' comp specific judges. These judges don't hear any other claims outside of the workers' compensation system. So if we win before a deputy commissioner, the meds will stay open. They may get a weekly check in addition to the meds staying open, but it's very rare that we close the indemnity and keep the meds open. Having said that, in order to continue to get medical, you have to see a doctor at least once every 2 years in order to keep that medical going under most circumstances. There's a way around it, but we don't see it used very often.
And Dave, along those lines of what Anne-Marie just said, we typically advise our clients, if you have meds open, don't go 5 years without seeing that approved doctor. Don't you think about once a year or every 6 months or so, at least check in, even if you're asymptomatic, just so there's a record that you don't report new injuries or you haven't done something that's inconsistent. Because what happens typically on down the road with the insurance carrier in an open medical situation?
Yeah, I'm dealing with it right now where a current client settled a work comp claim 10 plus years ago, and she never, she settled with medical benefits open 10 plus years ago. And she never followed up with the doctor during that time. And she contacted me about another work comp claim. And she said, oh, by the way, I need to see my doctor on this old claim. And so I contacted the old adjuster on that one. She said, it's been 10 years. And so that was 3 months ago, 4 months ago. And now the adjuster has ordered all the old medical records, and now she wants to take a recorded statement. So it's just this process because my client never went to see her doctor in that 10 plus years.
Yeah. And Annemarie, as you said a few minutes ago, sometimes it's a burden. It's just not worth to keep medical care open. Anyway, I'll put a cork in that. But you, Annemarie, you've already kind of touched on how trials are dealt with through administrative law judge who is dedicated in work comp. Dave, do we have that in our lovely state, our system?
No, we're unique for so many reasons, but specifically, we are the only state where when you have a dispute in a work comp case, you go directly to the trial court. We don't have an administrative system here in Alabama for work comp. So the same judges that hear car wreck cases and contract disputes and criminal matters and medical malpractice, we go to that judge for our disputes to have work comp trials.
And Annemarie, there may be 1 out of every 10 judges who we may appear in front of around the state who have any experience with work comp.
That would be horrible. I would hate that.
It takes a lot of education, particularly if you have a newer judge who's new to the bench who may have no experience with work comp. They're really going to rely upon the parties, the counsel parties, to streamline and educate them. So it's just another layer of our work comp system here.
Well, that would be frustrating because workers' comp is such an esoteric system. Unless you really practice it all day, every day, it's very easy not to understand the nuances that workers' comp has. We actually try our cases backwards in North Carolina. I always tell folks from other states, they're always kind of amazed by this. So we file a claim, just say it's denied. We request a hearing before the judge. We engage in discovery. We do not take depositions. We go to mediation with just the written discovery responses. The case either settles or doesn't settle. If it doesn't settle, we march on to a hearing. And the hearing is the first time we've heard what the other side has to say. There's no depositions prior to the hearing. And then after the hearing, we have 60 days to take doctors' depositions. So we don't know what the doctors are going to say until after the hearing. Then we have 30 days to write legal briefs, and then we get a written decision maybe 4 months after that. So very different than I think most states handle things.
Yeah.
I'll say this about Alabama. We do have it right, I think, in the sense, Annemarie, was when we have a denied claim, we go to court, we have a bifurcated system, okay, bifurcated trial.
Right.
So the judge will hear just try the compensability part relatively soon. And then later on, once the injured worker reaches MMI, then the judge will decide degree of disability.
And I think that's smart because sometimes we don't have a full picture of what the damages are if we have to go get a ruling on compensability. But it takes so long to get to a hearing to begin with. By the time we get there, we have some idea. But I'm sure, as y'all see, we have to figure out how to get our person treated in that interim period, which is always its own challenge. So
it truly is. And guys, we've got one more comparison I want to make within the work comp world of North Carolina and Alabama, how we do things a little differently. And Dave, we'll start with you on this part. When we resolve a case in a trial, we get a court order. One of the hardest things to explain to our clients is how and when they're going to get their money. Because part of the money can be paid in a lump sum, but part of the money has to be paid out into the future unless post-trial, post-verdict, the parties come to an agreement that changes all of that. So from a bird's eye view, can you kind of explain the lump sum versus the future monies?
Yeah. So if we don't have a trial, we reach a settlement, then our client's going to get their money in a lump sum, a one-time payment. If we go try the case and the judge rules for our client, then their weekly benefits are going to be paid, their future benefits are going to be paid out on a weekly basis. They will get in a lump sum any money that's accrued. That means from the date of MMI up to the trial date, or when the judge enters the order. So at trial, the money's going to be paid out on a weekly basis. I've got one right now where we tried in 2020. We won that one. They've been paying, the work comp's been paying out weekly permanent and total disability benefits, but now work comp is interested in a settlement of that. And so now they're offering a lump sum settlement, meaning they can stop paying the weekly checks and then just pay my client in a lump sum basis.
And Dave, to follow up on that, what happens if our client were to die before all the payments are made, those future payments?
Those payments stop upon the death of the employee or our client.
Yeah, there's no beneficiary in that situation unless we had a little bit different fact pattern, unless we had an annuity where there's a designated beneficiary, but that's not our situation. They're just out there. What about Annemarie? When you reach a trial and you get a verdict and your client is awarded benefits, how are they paid?
Exactly the same way as in Alabama. Accrued benefits in a lump sum, then future benefits as they accrue. And to your point about dying, it is unfortunate. I had a situation where we had a $125,000 offer, or maybe it was a $100,000 offer on the table. We were trying to get a little bit more and declined the offer. And then the client passed away a couple months later from unrelated issues. And the wife said, well, is it too late to take that offer? And I said, unfortunately, it is. So, you know, these claims do end when the client dies. And so that is something to take into account if my client's, you know, got some health issues or other issues that may impact, you know, the reasons that we do settle. But same thing, if we go try, and that's why you can kind of get more money by settling, because you can look into your crystal ball and reduce things to lump sums, and sometimes by even trying and winning the case.
You know, your fact scenario I've had happen 2 or 3 times to me. And after the first time, we learned very quickly, as soon as you can get it reduced to writing the agreement, then it becomes enforceable if he happens or she happens to die after, but before it gets court approved. But you just, you never know, that's for sure. Well, guys, we've reached the itinerary of this month's episode. So I want to thank you both for your expertise, your enthusiasm, and just sharing your thoughts about this. Annemarie, before we cut you loose, any final words, anything you want to share with us about North Carolina law, or maybe the snowstorm you're about to get in Charlotte this week?
I know, the 3 inches, then that'll shut down you know, we're in the South too, so snow and us don't mix very well. Now, what I will just say is I love being a workers' comp attorney. I prefer it to even the civil stuff. My law partner does the car wrecks and the slips and falls. I just handle workers' comp, and I love the academic piece, but I love the human piece. Every state is different, but the concepts are similar. And I will say, I think if I were to practice anywhere, North Carolina is a pretty good place to practice. But having said that, the comp system in general can be very frustrating for our clients. There's so many hoops. It's become very adversarial in the last, I would say, 10 years as managed care gets more involved. And there were so many vendors that I call it the workers' comp industrial complex. How many people does it take to send somebody to the doctor? Like 10. So, but having said that, I love what I do. So if y'all have anything in North Carolina that you need help with, I'm happy to help out.
I put a link to your bio page from your website in the show notes, but tell us, how can folks get in touch with you?
Send me an email, amp@wilderlawgroup.com. I took my last name out of the URL because it's too hard to spell, but so amp@wilderlawgroup.com, or they can give us a call at 704-342-2243.
Thank you. And Dave, if we get a 1/4 inch of snow in the Birmingham metro area, what happens around here?
Bread and milk sales go through the roof, and we aren't going anywhere for a while.
Nowhere. That's right.
Annemarie, you brought up an interesting point. I wrote a CLE paper several years ago about all the people that are involved in the work comp case, all the hands that touch, to get someone to a doctor or, through the work comp system. And, it took them an entire page of people. You're right. It's a work comp industrial complex. That's a great way to put it.
Yeah. And I tell people you just need a guide. It's not an intuitive system. And we guide people through this system as they experience it because it's not intuitive. So.
And I'm amazed and somewhat frustrated by the number of people who think, oh, it's just a work comp claim. My employer or the adjuster or the case nurse will take care of me and guide me through the system. Well, they're not looking out for your best interests. So my point is, if you've been injured and you're watching this, you need to call a work comp lawyer, talk to them, ask questions, get information. Don't do this by yourself. Don't try to be an internet scholar and just look it up, because you might be looking up another state's laws that have nothing to do with the state you're in.
That's right. All states are different, for sure.
I wish I could take what you just said, David, and put it in bold and then shout it at everybody who comes to our YouTube channel or our website. Don't let the internet be your lawyer.
Right.
But if you happen to be watching our show and you're from a different state, but you're interested in this topic or you have something, contact Annemarie or contact our firm, and we'll get you to the lawyer from your particular state who's experienced. This is the plug, Dave, where we are in the show. We're almost finished. I want you to talk about WILG and how we know Annemarie and why this is such an awesome organization that we all three belong to.
Sure. Yeah. So WILG is the Workers Injury Law Advocacy Group, and it's comprised of about 1,100 lawyers from around the country who only represent injured workers. That's all these lawyers do. They represent people in work comp claims, Social Security disability, where they get hurt on a federal property or, on water. But that's all they do is help people who have been injured at work. And it's how we become friends with real good lawyers like Annemarie. So if we don't handle a case in, say, Texas or Oklahoma, well, we probably know a lawyer in that state, and we can get you to them. And that way you're in good hands with a lawyer who specializes in workers' compensation.
Couldn't have said it any better. Annemarie, thank you for joining us this month. We really enjoyed our time with you today.
Well, thanks for inviting me. This was fun. All comp all the time. It's wonderful.
There you go. There's the new slogan, all comp all the time.
Nice.
Dave, any last words before we scoot?
No, wish everybody well. Take care.